So thank you so much, everybody, for joining me tonight. It's really lovely to see you all joining back, and welcome if this is the first webinar you've attended. So as usual, I do like to kick off with a bit of a shout out to the Bite Medicine platform. I'm sure you will all know about this platform by now, especially because I've been plugging it every session, but just to remind you that the session includes a Q&A, question bank, and also a very helpful online textbook for you to use. And as I've mentioned multiple times, I am somebody that used Bite Medicine during medical school, and I cannot recommend the textbook enough. It is honestly a fantastic resource for your finals and for your exams. So do definitely make sure to check it out through the link in the top right hand side of the corner. So as usual, I do like to introduce myself a little bit in case this is the first of my webinars that you've been attending. So hi everybody, my name's Shivani. I am a graduate of the University of Birmingham Medical School, and I applied to the SFP last year in the West Midlands and in London, and I ended up choosing a post in medical education in the West Midlands, and I'm currently looking towards a medical career with a mixture of research, teaching and clinical roles. And I put my contact details on the slides there, so if any of you ever have any questions about both this session or any of the other sessions that I've done, please feel free to email me or contact me on Twitter. I'm always happy to take your questions. So today we are on our penultimate lecture in the series, but don't worry if you haven't managed to catch the others, because they're all available both through the Bite Medicine platform and for free as well on YouTube as well through the Bite Medicine channel. So you can always catch up on them on demand there as well. But today we're going to be talking about ethics, law and key medical guidance. And this is a really important and often overlooked topic that's important not only for your SFP interviews, but also both for your clinical practice and for your SJT exam as well. So making the step in joining this lecture is a really great start. And we're going to be doing a whistle-stop tour of all the key medical ethical principles, key laws that you need to be aware of, and also a little bit of a look at good medical practice, which is a key guidance that we use for guiding our clinical practice. And I'm expecting the session to be around an hour. We will be using Menti in this time as well, so please have your phones there and ready. So I'll be giving you a code and there'll be an opportunity for you to participate in a couple of anonymous quizzes as we go along. So let's start with a quick icebreaker so I can get an idea of where you guys are at and what you already know. So first of all, if we go to menti.com, can you let me know what year group you guys are in? So if I switch over to Menti, if you type in the code in the top hand corner there, so 14404049, let me know what year group you guys are in. Okay, so we're looking at final years so far. That's very good to know. Hopefully this lecture will be well pitched to you. Alrighty, looks like we're looking mainly at final years for now, isn't it? Oh, maybe a fourth year as well. Lovely to have you all. Thank you so much for joining. Firstly, I'd also like to find out about what you already know about ethics and how you can apply it in your clinical practice. So I appreciate this may be a topic that some of you will have covered in your medical school before, but in case you haven't, just let me know how confident you feel about this. Okay, so we feel quite neutral about this and not very confident. So don't worry, we'll be starting from scratch today. So I'll be going through some of the basics of ethics, and hopefully by the end of the session, you'll feel a lot more confident in it. Okay, and my last question for you all is, how confident do you feel about knowing and applying key medical guidance that we use in the UK and current laws that govern your practice? So again, if we go back to menti.com and we go to the next slide, let me know how you feel about key medical guidance. Okay, less confident on this. Not to worry, this is a topic that isn't often covered in medical schools as extensively, but hopefully by the end of the session, you'll know a bit more about common laws that we need to be aware of in our clinical practice and use. Okie dokie, let's head back to the presentation. So first of all, just as in a bit of an introduction, I just wanted to emphasize why this topic is really important. So obviously, when we think about ethics and law, fundamentally in the UK, it underpins all the practice that we undertake as doctors, and it very much guides our decision making for patients. And you'll see this time and time again on the wards. And so in a kind of assessment setting, such as an interview, your understanding of these sorts of principles is used as a way of trying to assess your ethical judgment. And a similar analogy would be when you apply for medical school, you will have done the SJT as part of your UK CAT or UCAT, as I think it's now changed to. So it's kind of a similar principle to that. And therefore, to kind of reflect that, the understanding of ethics and the demonstration of that is often rewarded in SFP mark schemes. So the way this could kind of come about is you might either be asked direct questions about ethical dilemmas that are obvious in the scenario, but even if you're not asked about it, as I say, it's often credited on the mark scheme. So always mention that you've at least considered the potential for any ethical or legal issues when you're answering, particularly in the clinical scenario and academic stations. So that way they can always give you that tick in that box for this section. So let's start at the very beginning with the pillars of medical ethics. So essentially, in case you aren't familiar with this concept, what this essentially encapsulates is 4 core ethical principles that all doctors should be aware of and apply in their day-to-day medical practice. And it should be a set of principles that we all adhere to on a day-to-day basis. So the 4 pillars are beneficence, which essentially means acting in the patient's best interest. And when we say best interest, we don't mean what we think is right as doctors, but what we think is the right decision for that particular patient, considering their views and their needs at that point in time. The next pillar is non-maleficence. So this is the classic do no harm in the Hippocratic Oath, and it's essentially making sure that you're not taking any action that would cause deliberate harm to our patients. The next pillar is justice, and this is a pillar that some people have a difficult time kind of conceptualizing, but the best way I find to think about this is the care you're providing fair to both the patient and the wider society. And core principles that are included in justice are principles of equality and equity of distribution of resources. And finally, the last pillar, which you'll see come up time and time again, is patient autonomy. So autonomy essentially means the patient's right to make a decision for themselves. And that's because in medical ethics, the patient is the person that knows themselves the best and what course of action would be best for them. So in the clinical setting, you will often see that doctors will do everything they can to empower patients to make their own decisions and be informed about their healthcare. And that all comes down to this pillar of autonomy. So let's think about how we can apply the pillars of medical ethics in an SFP interview. And the first way in which this could come about is in your clinical scenario. So those of you who attended the clinical station webinar, you will remember this scenario in which I introduced 2 patients, one of whom has melena and the second of whom is having a bit of nausea and generalized abdominal pain. So I'll just give you a quick second to read that scenario in case it's something that's not familiar to all of you. Okay. So if you attend this webinar, you'll remember that I mentioned that one of the ways in which they test you in this station, particularly in the A2E stations, is to think about any ethical and legal issues in the case. And as I said before, it's often credited in the mark scheme, even if they don't bring it up directly. So always mention it. So if we kind of use an example of a follow-on question, this is an example of what they might ask you. So essentially, the crux of this little follow-on brief is that when you see the second patient, they're drowsy, and you need to start emergency treatment. So this is an example of where you might need to use the 7 pillars of medical ethics. So if we think about how we could potentially apply that in our answer, if we first of all take the principle of beneficence, we could argue that in this scenario, giving the patient treatment for their DKA will help them feel better, and therefore it is in the patient's best interests. And actually, you could also kind of flip that on its head in your answer and say that it would be non-maleficence to not initiate treatment, because that could potentially cause harm to the patient and maybe even, unfortunately, cause their death. In terms of kind of principles of justice, there aren't any immediate issues to do with kind of equality and equity of distribution of resources. And in this scenario, when we think about autonomy, because the patient is drowsy and confused, they're not necessarily in the best situation to be able to make a decision for themselves. And in that scenario, it's important to say that you would take on the role of acting in the patient's best interests. So you can see that working through the 4 pillars of medical ethics in response to this sort of ethical issue gives you a nice structured way of considering all core medical ethical principles in your answer and providing a structure by which you can answer any follow-on questions pertaining to ethics. So the other way in which the principles of ethics can kind of come into your interviews is in the academic station. And those of you that attended the academic station scenario will remember that I presented to you this abstract regarding dexamethasone in hospitalized patients with COVID. And just as a summary, while you guys are skim reading this, this is essentially a large randomized controlled trial that was conducted in an international setting, looking at comparing patients with dexamethasone to patients who receive standard care and looking at whether that improved their 28-day mortality. So if you went to that webinar, you will remember that I introduced this approach to critical appraisal. And you can see on this slide that consideration of ethics is one of the core parts of your critical appraisal. So we're going to talk through how you can use the 4 pillars of medical ethics now to kind of answer that part of your critical appraisal. So if we take our pillars of medical ethics and link them back to that abstract, if we look at the kind of principles of beneficence, so acting in the patient's best interest, you could argue that this trial was in the patient's best interest, because we could say that by investigating dexamethasone, there was a potential to improve the care of patients with COVID-19 at the time. And importantly, for randomized controlled trials, you can argue that it was non-maleficent because the authors maintained a position of equipoise. And this is a really core ethical principle for randomized controlled trials. What equipoise essentially means is that the authors genuinely didn't have any idea as to whether one intervention was better than the other. And that means they can approach the trial in good consciousness that they're not actively and knowingly causing harm to the patients by giving them this experimental treatment. In terms of justice, you could argue that the recruitment setting was quite large and patients were randomly assigned to each of the trial arms. So this might potentially suggest that access to kind of the intervention therapy was equal and equitable in the trial. And finally, from an autonomy perspective, this is all to do with kind of consenting to research. So you could argue that in this particular example, autonomy was respected because the patients had to provide informed consent to participate in this trial. And you could mention that when you're appraising the article in full, you would look for their consenting procedure to make sure that was done. So again, like with the clinical scenario, working through the 4 pillars of medical ethics gives you a structured way of thinking about any ethical issues in this piece of research. And key things to look for, particularly in randomized controlled trials, are that position of equipoise, how participants were recruited to the study and consented, and how participants were randomized. But don't forget, an important part of ethical appraisal as part of your critical appraisal is to think about whether the authors received any funding and whether they have any conflicts of interest, by which I mean they are kind of funded or sponsored by a particular company which has a direct and competing interest in the outcome of the study at hand. So always look for and mention that you think about those issues as well. So that's kind of the pillars of medical ethics and applying those in a nutshell. Does anyone have any questions at this point about that section? Okay, so I think we're all happy for now. So what I'm going to do is I'm going to move on to the next section, which is all about consent, capacity, and competence. And again, these are really commonly tested issues, both in SFP interviews and in your SJT as well. So let's take a look at an example scenario just to introduce this topic. So this is the scenario that I presented. It links back to the clinical scenario I introduced, in which we had that patient with the melena who had the low blood pressure. And the scenario essentially says that when you go to see them, you believe that they need a transfusion and you need to activate the major hemorrhage protocol. But the patient tells you that they're a Jehovah's Witness and they don't want to receive this transfusion. So if we go over to Menti, what I'd like you to do is tell me whether you think you should transfuse this patient or not. Okay, good. No, we've got some answers for no. Lovely. Well done, guys. So yeah, this patient, we shouldn't transfuse. And is anyone able to let me know in the Q&A why we shouldn't be transfusing this patient? They have capacity. Well done, exactly. So essentially they are deemed to have capacity. There's no indication that they don't have capacity at this point in time, and therefore they are able to make an informed decision to decline treatment. And that's valid, even though it's not necessarily going to help their situation. So let's look at that principle in more detail now. Firstly, starting with consent and capacity. So firstly, what is consent? It essentially refers to patients providing permission to have any form of care. So that includes being investigated, being examined, and receiving treatment as well. And to have consent, or to have valid consent, you need to meet 3 principles, okay? So the consent must be informed, so the patient must have adequate information about what it is you're going to do so that they're able to make the decision. The consent should be voluntary, so it should be entirely the patient's own decision, and there should be no risk of coercion from any other external parties. And finally, the patient should have capacity to make consent. And what does capacity actually mean? It essentially refers to a patient's ability to make a specific decision at a specific time point. So that's really important to understand, because just because a patient doesn't have capacity at one time point, it doesn't mean that they don't have capacity overall. So they might have capacity at a different time point or to make a different decision. And therefore capacity is decision specific. So what are the principles of capacity? The best way to kind of summarize this from the key medical guidance is PLUM. So this is the idea that you should presume everybody has capacity, and that just because somebody makes a decision that you don't think is wise, it doesn't mean that they don't have capacity. Essentially, in patients who we're worried don't have capacity or might not have full capacity when you first go and assess them, we should try and look for ways of maximizing their capacity, so reversing any reversible causes. And you should also think about, if you have to make decisions for patients, you need to choose the action that means that they have the most options available to them later down the line, and you should also be acting in the patient's best interest. So how can we go about assessing capacity? So there are key criteria for the assessment of capacity, and it essentially revolves around asking 2 questions. The first question is, does the patient have a disturbance to the function of their brain or mind? So essentially that means anything that is kind of causing long or short-term confusion or cognitive dysfunction, okay? And if they do have such a disturbance, you have these 4 functional tests that you need to run through with patients to check whether or not they're able to make a decision at that time point. But if they don't have any disturbance to the function of their brain or mind that you can see, then you should assume that that patient has the capacity to make that decision. So if we link this back to our scenario, the reason why that patient had capacity is because there was no suggestion that they had a disturbance of the function of their brain and mind. And we'd given them the relevant information, and the patient had made a voluntary decision not to consent to treatment. So this kind of begs the question, what would I need to do if I've done this assessment and I've decided that my patient doesn't have the capacity to make a decision? So essentially, the way you act is essentially revolved around trying to empower the patient to at least be involved in the decision-making process as far as possible. So the first thing you should try and do is, in line with those Plum principles, you should try and identify and correct anything reversible that could be affecting the patient's capacity to consent. So say, for example, if they have an electrolyte abnormality that's making them confused, you should try and correct that electrolyte abnormality and then try and seek consent later on once that has been corrected. If there are no reversible causes, the next thing you need to do is look for any documentation the patient may have provided about what they would want for their care. And key documentation we use in the clinical setting are advanced directives, which are essentially formal statements written by the patient about the care they would like to receive. This is not legally binding, but it is indicative of what the patient would want for their care. The second document we would look at are advanced decisions to refuse treatment. So these are legally defined, legally binding documents, and they essentially state what the patient would not like for their care, or anything the patient would like to flat out refuse in the instance they lose capacity. And the final type of documentation we look at are DNA CPR documents and sealing of care documentation, which is sometimes called a respect form. And this is kind of a summary document that we use in the clinical setting, which encapsulates all of the patient's sealings of care and their wishes for their care should they lose capacity in an emergency situation. So if they don't have any of these documentation, the next step would be to look for lasting powers of attorney of health and welfare, okay? And it's important that it is an attorney of health and welfare, because there is another type of LPA which relates to financial matters. So it has to be a certain type of LPA. Another option would be to look for and seek guidance from the designated next of kin for that patient as well. And if they don't have any relatives or any LPAs available, you can ask for what's called an independent advocate for the patient, an IMCA. And they are essentially a person that is designated to look through all of the patient's notes, speak to their relatives, look through their history to gain an idea of what the patient would want for themselves. So they essentially act as an advocate for that patient in line with what we know about the patient and what they would want for their care. And the idea at this stage is that person would make decisions in line with the clinical team, acting in the patient's best interests. And if that's still not possible and you still can't come to a decision about what to do, you could pursue a more legal route. And there's something called the court of protection, where cases are presented and a judge will make a clinical assessment about whether or not to proceed with a particular treatment. So with that in mind, let's now look at competence. So competence is essentially a legal term for capacity. So it essentially encapsulates an ability to make a decision. And in legal terminology, competence is used interchangeably with capacity. So you will often see people using a mixture of both terms, and they mean effectively the same thing. An important caveat to competence to be aware of in an interview setting is Gillick competence. So the Gillick competence law is essentially a law that arose around a case about a child's ability to consent to treatment. And what the law essentially says is that children under the age of 16 are still able to provide consent to treatment if they can demonstrate that they meet the criteria for capacity. So if you were to run through those 4 tests of capacity, they are able to meet all 4 of those tests, and therefore they are able to demonstrate competence in making a decision. So it's important to be aware of the caveats for Gillick competence, because in the UK and in England, there are certain instances where that capacity can be overruled. So if the child is consenting for treatment, there is no circumstance in which that decision can be overruled. Okay, so that decision is an absolute decision. However, if the patient is refusing treatment and the treatment would potentially be in that child's best interest, that decision of refusal can be overruled either by the patient's designated parents or legal guardian, or by the court of protection. So that brings us to the end of talking about capacity and competence. Does anyone have any questions at that point? Okay, I think we are all happy for now. So let's move on and crack on with confidentiality, which is another key principle. And again, I have an example scenario to ask you guys and introduce this topic. So this is my scenario. Essentially, you're working in a sexual health clinic and you've got somebody who you've diagnosed with gonorrhea. And as per standard recommended protocol, you need to contact trace their close contacts. And so you ask the patient for their permission, but they don't want to give it to you because they're worried about the impact it will have on their life. So if we go back to Menti, what I'd like you to do is tell me whether you think you should break this patient's confidentiality. Feel free to have a guess. Okay, yes. So we've got one option for yes. Well done. Okay. Any other thoughts? Okay, so yes is actually the answer I was looking for, with the caveat that you should try and work with the patient first. And we'll talk through why that's the answer in a minute. So let's start off by talking about confidentiality in a broader context. So essentially, this is the legal and ethical duty that doctors have to keep patient information private. So essentially, there are 8 principles of confidentiality that have been laid out by the GMC, and I'll let you read these in your own time in more detail. But essentially, what this encapsulates is that you should try and use the minimum amount of data possible. If you need to use data, you need to use that data responsibly. So make sure that you're being careful with sharing that data and only sharing it with relevant persons. And if you do need to break somebody's confidentiality, you ideally need to be doing it with the patient and with their permission. However, having said that, there are certain caveats in which confidentiality can be broken. So the first is obviously the patient consents. So say, for example, in our situation, had the patient consented to contact tracing, we would have been able to break their confidentiality then. The second case is the patient lacks capacity to consent to disclosure, and it's in their best interest to share their information. The third situation is if there is a significant potential risk of harm to either the patient themselves or another person. And this is essentially argued as being breaking confidentiality in the public interest. And this includes scenarios such as situations of potential abuse. And finally, there is a requirement by court and law. So say, for example, in communicable diseases, such as in our case here, where we've got somebody with gonorrhea, it is a statutory obligation to disclose that for the purpose of contact tracing. And also, if there's a court order in place, you'd have to share that information then. So those are 4 very important caveats to be aware of in terms of breaking confidentiality. So let's now move on to talk about detention of patients and laws governing detention of patients, because again, this is another common thing that you will see in both clinical practice and in an interview setting. So in terms of kind of detention of patients, the first law to be aware of is the Mental Health Act of 1983. And essentially, this is a very important law that governs our ability as doctors to detain patients with mental health disorders for assessment and treatment. And there are certain criteria that you have to meet to be able to be detained under the Mental Health Act. So the first thing is the patient needs to have a mental health disorder. And not only do they need to have a mental health disorder, the severity of that disorder and the disease course of that disorder should be such that the patient needs treatment and assessment and therefore warrants detention for that purpose. Okay, so an example would be in a schizophrenic patient. We know that schizophrenia can unfortunately become very severe, and the nature of schizophrenia is such that without treatment, patients will get worse and worse and will potentially be of harm to themselves. So that is an example of where someone might warrant detention for assessment and management. The second criteria is that they should be at risk to themselves or to others if they were not detained, and they're unable to be managed in the community because of that level of risk. And finally, and importantly, the patient is not in a position where they can consent to the admission themselves, so they don't have capacity. And you have to meet all 4 of these criteria to be detained under the Mental Health Act. So when we think about the Mental Health Act, there are lots and lots of different sections of the Act under which patients can be detained, but there are 5 key sections that you need to be aware of for the purpose of kind of your clinical practice day to day and also for interviews. So the first are your temporary holding powers, so section 5.2 and 5.4. As doctors, section 5.2 is the one that applies to you. And essentially, it's the holding power for doctors who are F2 and above to detain patients for assessment. And it lasts 72 hours. And this should be happening outside of A&E. So if you've got a patient in A&E, you cannot section them under section 5.2. Section 5.4 is a very similar power, but it's for mental health specific nurses. Then you have your more long-term sections. So the key ones to be aware of are sections 2, 3, and 4. So section 2 is detention for assessment lasting 28 days. And you essentially need 2 doctors and 1 allied mental health professional to make an assessment and recommend detention for this. Section 3 is detention for treatment. So again, you need the same group of 3 people, and this time you're assessing people for potential detention up to 6 months for treatment. And finally, section 4 is if you're in an emergency situation and you've got someone who needs assessment, but you don't have those 3 people available to make that decision to recommend for detention. And the only person that's able to section somebody under this act in this section is somebody who is a qualified psychiatrist. So that's what a section 12 doctor means. So the next type of detention power that you need to be aware of is what's called deprivation of liberty safeguarding. And this is actually a law that is currently under review, and they're changing it into a new scheme, but this is the current scheme that's in place. So firstly, what is deprivation of liberty safeguarding? You might hear it called DOLS from time to time. And essentially what it means is it's a series of assessments that protect patients against wrongful deprivation of liberty, so wrongful detention in a care setting. And essentially what this involves is assessing patients to determine what the minimum number of steps are that we need to take in terms of depriving patients of their liberty that are needed to keep the patient safe. Okay. And this power is granted under the Mental Capacity Act rather than the Mental Health Act. So the types of patients that could benefit from DOLS are patients who are in a care setting, so either in a hospital or a care home, and they are patients who lack capacity to make decisions for themselves. They are under constant supervision from healthcare staff, and as a result of all of this, they're not free to leave their care setting. So there's a whole list of patients to which this could apply, but that's kind of a summary of the types of patients DOLS applies to. There are 2 main types of DOLS to be aware of. The first is urgent DOLs. So this is essentially in an emergency situation, if you need to place some form of restriction on a patient, for example, say, for example, you need to restrain a patient, then you can put in an application for urgent DOLs. And this is applied for by a representative in the hospital, and it lasts for 7 days. If you need to put kind of detention sort of implications on patients on a more long-term basis, then you can apply for standard DOLs. And again, you have a little assessment team made up of a qualified psychiatrist and somebody there to represent the patient's best interests. And you submit that application to the local authority, and it can last up to 12 months. So those restrictions can last up to 12 months. So that brings us to the end of kind of the law chunk of this lecture. Does anyone have any questions at this point? Okay, so I think we're all happy. So let's move on to the last part of the lecture, which is about good medical practice, which is essentially your fundamental key medical guidance that is absolutely vital to know about for your SJT in particular, as well as your SFP interviews. So first of all, hopefully you guys know about this already, but let's just introduce what good medical practice actually is. So it's a guidance document that's been written by the General Medical Council for UK junior doctors. And essentially, the goal of good medical practice is to outline core qualities and professional responsibilities that the GMC expects of its doctors to maintain in a day-to-day regular basis. And there are 4 domains of good medical practice that the GMC look for in its doctors that are currently tested in the SJT. So the first is relating to your knowledge, skills, and performance. The second is safety and quality. The third is about communication and teamwork. And the fourth is maintaining trust. So let's look at those in more detail, starting with domain 1, which is all about knowledge, skills, and performance. So essentially, this domain is kind of the technical domain of good medical practice, and it's all about doctors' responsibilities to maintain an adequate level of care and keep their knowledge up to date. So your core responsibilities that you need to be aware of under this domain are the fact that you need to make sure that you're completing your work to a high standard. You need to be aware of good medical practice as a guidance, and also core kind of NICE guidance and other guidelines that we use on a day-to-day basis. And you need to make sure that you're constantly providing a good level of care and keeping legible documentation to support your clinical work and your clinical decision making. So that's why in the clinical setting, you will always see people hammering home about kind of continuing professional development and making good legible documentation, because it all relates to domain 1 of good medical practice. So the next domain is to do with safety and quality. So this is all about protecting our patients and preventing errors in the clinical setting. And so your key responsibilities here are all about kind of adverse incident reporting and quality assurance through audit work and QI. And an important part of this domain is about supporting the duty of candour, which we'll talk about in just a moment. The third part of this is communication and partnership and teamwork. And this is all about how you work with your patients and how you work with other colleagues. So essentially, it's all about your communication responsibilities, and key things that you need to be aware of in this domain are your duties to maintain effective communication with your patients and also their relatives. And this is in line with the principle of autonomy, if we link back to that. So we need to be empowering our patients to make their own decisions and know about their healthcare. We need to be kind and courteous when working with our colleagues, and kind of willingness to teach junior colleagues and mentor colleagues comes under this domain as well. And the last part is maintaining trust, and they love this in the SJT. And this is all about upholding patients' trust in medicine and doctors as a profession. So the way in which the GMC expect us to do this is by constantly showing respect for our patients, being honest in all of our dealings, and maintaining a duty of candor when mistakes occur, because mistakes will occur. It's about how we kind of respond to it that's important. And with that in mind, let's now talk about the duty of candor. So the duty of candor is essentially a legal duty in which doctors and medical professionals in general have to disclose errors that have led to some form of more severe harm to the patient, or in an extreme case, to the patient's death. And this links back to our pillars of medical ethics in terms of doing no harm to patients and acting in the patient's best interests. So with the duty of candor in mind, let's now think about what you should do if you make a mistake in a clinical setting. And this is often tested in kind of an SFP scenario or in your SJT as well. So what the GMCs say when you make a mistake is that you need to follow 4 key steps. The first thing you need to do is obviously prioritize the patient's safety. So you need to identify and fix the mistake as quickly and as completely as you can. And in doing so, the GMC recommend that you reach out to your consultant or your senior colleagues for support in fixing that mistake. Once you've ensured that the patient is safe, the next thing you need to do is to apologize to the patient for what's happened. And the GMC very helpfully give a good structure for how that apology should be structured. So essentially what you need to mention is what exactly has happened, what the potential short and long-term consequences are to the patient, and also what actions have you taken to correct that mistake. So once you've kind of spoken to the patient and apologized to them, the next step is to report that incident. And this links back to domain 2, which is about safety and quality. And trusts will have a formal reporting process for these sorts of incidents. And most commonly, it's known as a DATIX, okay? In some trusts, such for example, in my trust, it's called an IR1. But the bottom line is you're using the trust's official reporting system to let them know that a mistake has been made and this is who was involved and this was what was done about it. And finally, depending on the severity of the mistake, you need to contact your defence union for more advice. So that brings us towards the end of the lecture. So these are the references. I've included the links to the kind of key medical guidance and the laws that we've discussed today. So do read those in more detail. And I'd be really grateful if you could fill out this feedback form, because I do genuinely read and take on board all of your feedback, and it would be very helpful to know if you found this lecture useful. Thank you so much for joining me tonight. And if you have any questions that you'd like me to answer, both about this topic and also any of the topics that I've discussed before, I'm very happy to take questions now. Can we go back to domain 2 and 3? Yes, we absolutely can. So I will skip back a couple of slides for you. So domain 2 is all about kind of maintaining patient safety. So essentially it's about recognizing errors, reporting errors when they come up, and also the whole point of audit and QI is to identify areas where practice could be improved and put in systems to kind of make that practice better. So that's domain 2. And domain 3 is all about kind of communicating with our patients and our colleagues. So as I mentioned before, it's all about maintaining good communication and empowering patients to make decisions. It's about how we work with our colleagues, and that includes teaching our colleagues as well. I hope that makes sense. Okay, so how would we answer a question on these in terms of the interview? So in terms of the interview, as we talked about with pillars of medical ethics, it's best to work through each of the pillars in turn and say from the perspective of beneficence, X, Y, and Z, from the perspective of non-maleficence, X, Y, and Z. In terms of kind of the laws and key medical guidance, the way in which these commonly come up is in the scenarios that you'll be given, there will be some form of ethical issue or legal issue. So say, for example, we looked at that case where the patient didn't want to consent to the transfusion. So what you would do in that case is you would state what the issue is. So the fact that the patient doesn't want to consent. You would mention the fact that this relates to the core issue of consent and capacity to consent. And you would mention that you would perform those functional tests that we talked about, so the disturbance to the function of brain and mind, and then kind of work through the functional tests as a way of justifying why you would or wouldn't take an action. So to kind of summarize, what you would essentially like to do in that sort of situation is summarize what the issue is, highlight which of these guidances is most appropriate to the scenario, and work through the core principles that we've discussed in this lecture for each of those as a way of justifying why you would or wouldn't take a particular action. I hope that makes sense. You're very welcome. I'm glad that was useful. Any other questions at all? Okay, so I think everyone's happy. I've not had any more questions come through, but don't forget, obviously, if you think of any more questions after you've seen this lecture or you've watched it back on YouTube, these are my contact details again, so do feel free to reach out. For now, thank you so much for joining. I really appreciate your time, and I will hopefully see you in a couple of weeks' time for the very last lecture in this series. But for now, take care. See you later.